All right. Welcome to your lecture on the United States or the U.S. Judicial Branch. So this is where we're going to be focusing on the federal court system here in the United States. So let's jump right in. All right, some basic information. If you remember from the Constitution only states that the judicial power of the United States would reside in one Supreme Court. That's how the Constitution established the federal court system. However, Article 1, Section 8 also gave Congress the power to create courts inferior from time to time. So this means that the Congress, right, the House of Representatives and the Senate, can create courts beneath the Supreme Court. This allows Congress to create other federal courts and potentially eliminate them as well. But this allows the federal court system to continuously evolve as the national needs change. Either the population is changing or the size of the country is changing. Congress can help the court system evolve with the country. The roles of the federal court system is first and foremost to resolve disputes. Now, in order for somebody to bring suit, they have to prove that they suffered damages in some way. And so that's going to be brought before the federal courts. The other thing that the federal courts do is they set precedent. This means that the decision is binding on all future situations that are similar. So when a federal court makes a decision, all future situations look back to that decision as kind of evidence of how to decide a case, right? So future cases can be decided or can use the decision to decide outcomes. And the final thing specifically for the Supreme Court is judicial review. Now, judicial review, this is where the courts interpret the Constitution, right? This is interpreting the law. I should not interpret the Constitution, interpret the law. This was not written into the Constitution that was ratified in 1787, but rather this was established by a court case called Marbury versus Madison in 1803. And we'll talk about that a little bit. All right, so now the what? Okay, so the district courts is the first level of the federal court system. There's 3 different levels. The lowest level are what we call the U.S. district courts. There are 94 different courts throughout the United States. They're divided up into 11 different districts. There is at least 1 district court per state. Some, depending on population, have as many as 4. So you can see on this map here, states like California or Texas, they're divided up into 4 different regions. You can kind of see these little dots here. And so each of these is going to have a district court in that region. Washington has 2, whereas states like Montana or Idaho or Oregon, they don't have any divisions there. So they just have 1 district court in their state. Who presides over these are the federal judges, right? There's 1 federal judge at each district court. These justices are appointed by the president and then confirmed by the Senate. And these judges serve for life or until they retire. The how it works at the district court level. So this is kind of what most people think of when we think of kind of courts in general, right? The U.S. district courts have what we call original jurisdictions on most federal cases. So they have the right to hear the case for the first time. So most federal cases are going to start here at these lower, what we call district courts in the district that a crime has happened or a civil suit is brought. So they provide, the district courts preside over these cases. There's 2 different types of cases that they hear. There's a criminal case where somebody has broken a federal law and they've been arrested by federal law enforcement and they're brought before a district court because of a criminal case. Or it can be a civil case. A civil case is where a person is suing the government or suing an agent of the government because that person or the government agency has violated their constitutional rights. Okay, and so that's a civil case. These are the trial courts. Okay, so the district courts are these trial courts. So federal cases are tried here where witnesses testify, federal juries hear the evidence and serve to make the decisions of the case. Evidence is presented, right? Kind of the traditional courts that most people think of. That's how the U.S. district courts run. The next level is what we call the Court of Appeals. So we have the lower district courts, and then above that is the Court of Appeals. The Court of Appeals only decide issues of law. And so what I mean by that is they have what we call appellate jurisdiction. So they review the decisions of the lower district courts and determine whether or not those decisions were correct. So the Court of Appeals, they have the right to hear a case that's already been decided on, right? So original jurisdiction means you hear the case for the first time. That's what the district courts do. Appellate jurisdiction means you have the right to hear a case that's already been decided upon. That's what we have here in the appellate court system. The appellate court, sorry about that. The appellate court justices, I did it again, I keep clicking on the picture. The appellate court justices, just like those district justices, are appointed by the president and confirmed by the Senate. They serve for life or until retirement, and each appellate court has 3 different justices. Now, the way that this works is the appeal has to be brought to the appellate court. Now, the appeal comes typically from the losing party at the district court. They make an appellate court, or they ask the appellate court to revisit their case and make a judgment on some issue of law. They can't just bring a suit to the appellate court because they're unhappy with the decision, right? It has to be on some issue of law. So maybe they can argue that the jury made the wrong decision because the attorney was incompetent, or because there was evidence that was excluded, or they can prove that the jury was biased, right? There's plenty of court cases that that we've talked about, even that have gone to the Supreme Court, that have had that as kind of the reason why they're moving up in the court system. There's no jury at the appellate court level, but rather written briefs from each side are submitted to the 3 justices ahead of time. They review those ahead of time, and then in the court, the day of the kind of hearing, you have oral arguments from each side. So a lawyer from one side stands up and they present their arguments, and the judges can ask questions. They can interrupt to ask questions, and they have a set period of time. And then the lawyer from the other side stands up and gives their oral arguments. Same thing. The judges can ask questions. After that, the justices then make a decision, and that's the decision. All right, and then at the very tippy top of our federal court system is the U.S. Supreme Court. The U.S. Supreme Court is the highest court in the land, and they have what I mentioned at the beginning, what we call judicial review. So judicial review is the right to interpret the law. This was established by Marbury versus Madison in 1803. And this really says that the court can declare any act of Congress or law that Congress has passed. They can declare that that act is void if it's inconsistent with the Constitution. And so you can see in this quote here that says, "It is emphatically the province and duty of the judicial department to say what the law is," right? This is a line directly from Marbury versus Madison. Okay, and so again, this is kind of your structure here, right? You have a bunch of district courts at the bottom, 94 of them, and then you have fewer appellate courts right there in the middle, and then just one tippy top Supreme Court. The Supreme Court's decision sets the precedent for all the lower courts. So the decision is binding on all future situations that are similar, and every court in the country has to follow the ruling that the Supreme Court makes from that point on. It's important to note that the appellate courts also, they set precedent, but they only set precedent in their district. So if you remember, let's see if we can go back a couple slides here to our image of our districts here, right? So if, let's say, the Ninth Court of Appeals makes a decision, that decision sets precedent, but only in the Ninth District. So all the district courts in the Ninth District, including Alaska, Hawaii, Guam, the Northern Mariana Islands, right? All of the district courts have to use that appellate court decision as precedent moving forward. Does not then apply, though, to the 8th District or to the 2nd District. Appellate courts only set precedent in their district, whereas the Supreme Court sets precedent for all the courts in all the states and all the districts. All right, and so the justices. The Supreme Court is made up of 9 justices. This was set by the Judiciary Act of 1869 that limited and kind of set that the size of the court is going to be 9 justices. Like all the other federal courts, the Supreme Court justices are appointed by the president and confirmed by the Senate. At the time of this recording, these are your current Supreme Court justices. Those 4 justices standing in the back row, those are the most recently appointed justices. From the left to the right, Justice Amy Coney Barrett, Justice Neil Gorsuch, and Justice Brett Kavanaugh. Those 3 were all appointed by President Trump in his first term. And then the one on the right, far right, standing up is Associate Justice Ketanji Brown Jackson. She was appointed by President Biden. So she's the most recently appointed Supreme Court justice. The Chief Justice is right here in the middle. So he is Chief Justice John Roberts. All other justices on the Supreme Court are considered associate justices. Okay, and so how is it decided kind of what cases the Supreme Court's going to hear? The first kind of rule of thumb, I guess you could say, is what we call the rule of 4. If 4 justices agree to hear a case, then the Supreme Court will take that case. They will review records from the lower court and then before the case actually comes before the Supreme Court, they'll review that. So they usually take cases that, that affect the entire country, right? They're not going to take a case that just affects necessarily the people in Ohio or the people in Washington, D.C., but rather they want to take cases that are going to affect the entire country, that have a large constitutional impact, or maybe answer an important legal question that will affect the whole nation. They also will sometimes take cases when lower courts can't agree on how to interpret a particular law or laws that have been interpreted differently by different states. This is an example of how Obergefell v. Hodges got passed in 2015, which is the law that legalized gay marriage across the country. Right before that, different states had different laws about recognizing gay marriages as legal or not. And so different states were interpreting laws differently. So that's one of the reasons why that case in particular in 2015 went before the Supreme Court. Now, they usually decide cases that come from the appellate court, right? So they usually work their way up. They start in the district courts, they go to an appellate court, and then they work their way up to the Supreme Court, though not always. Sometimes they can hear cases directly from a state Supreme Court. So each state has their own court system. And then sometimes at a state Supreme Court, it may go from a state Supreme Court up to the federal Supreme Court. It just depends on the case, depends on the issue. The Supreme Court has original jurisdiction, the right to hear the case for the first time in very few cases. According to the Constitution, the Supreme Court has original jurisdiction when a state is a party. So if somebody's suing the state of Ohio or the state of California, or if there's cases involving representatives of a foreign nation. So if the ambassador to France is suing the United States, that can go to that. Then the Supreme Court has original jurisdiction, the right to hear the case for the first time. So it doesn't have to work its way up to the Supreme Court. The Judiciary Act of 1789 added some things, and so that's what you'll see here. If there's a case where there's suit between 2 states, so here you see California and Nevada are suing one another for some reason, that can go directly to the Supreme Court. Also, if it's between a state and a foreign government, is another time where the Supreme Court has original jurisdiction, the right to hear the case for the first time. Similar to the appellate court, as I mentioned already, the Supreme Court justices review kind of these written briefs ahead of time. And then, although there's more than 3 justices, this is obviously the appellate court here, but the process is similar. The lawyers they stand up, they give their oral arguments. There's a specific amount of time that they can give those arguments, and the judges can ask questions. They sit down, the other side then presents their oral arguments, and then the justices make a decision. They make a decision, and when they deliver their decision, it's called an opinion, right? The majority opinion is the decision that the majority of justices made, and that's the decision that sets precedent. That's the binding decision. The justice who writes the decision is appointed by the Chief Justice. Even if the Chief Justice is not in the majority, the Chief Justice decides who writes each decision. It's usually on kind of a rotating basis. Justices can also issue what's called a concurring opinion. A concurring opinion is when a judge agrees with the decision of the majority. However, they have a different reason as to why. This is called the reasoning. And so they may say, look, yes, this is the right decision, but I think the reasons are different, and here's my reasons for coming to that decision. And then also you can have a dissenting opinion. The dissenting opinion is from the justices who disagree with the majority. So they disagree with the decision that the majority made, and they can write their dissenting opinion and why they think that the majority of their colleagues are incorrect. Sometimes these dissenting opinions can actually be used in future cases as well. And so they do become an important part of the legal process. All right, so that is it for our federal court lecture at this time. Thank you so much for listening, and as always, please feel free to ask if you have any questions in class.